I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, this is number 235 on our compilation list. We will be in 3 different courtrooms. Before I give you those courtrooms, the names of those courtrooms, we will have commentary in these videos. Also, chapters will be added for your convenience. Don't forget to like, comment, share, and subscribe. It helps us out tremendously. And now let me give you the rundown of the courtrooms that we will be in on today. First, we will be in the courtroom of Judge Elizabeth Disanto out of the state of Michigan. Second, we will be in an unknown court today with an unknown judge, but shout out to Sovereign Citizen Chronicles for sharing this one with me. And last but not least, we will be in the courtroom of Judge Tammi Hayward out of the state of Georgia. And for all 3 of these, we got a lot of fireworks, a lot of feisty moments, a lot of aggression, whether that's from the judge or the sovereign citizens. So I'm sure, that you guys are going to enjoy. I'm all tongue-tied today. Number 235. So I don't keep getting tongue-tied here, let's just go ahead and get into this next compilation, 235.
For the people, please. Ms. Bella? Ms. Bella, can you please place your appearance on the record? Ms. Bella? Okay, counsel, Mr. Pervin Keller, your name for the record, please.
Good morning, Your Honor. Yvonne Parabon Keller, P84328, appearing on behalf of Mr. Bradley Peterson, who is present today in the courtroom.
All right, thank you. And Mr. Peterson, for the record, please.
Bradley Thomas Peterson.
All right, thank you. And Ms. Bella, your appearance for the record, please.
Good morning, Your Honor. Michaela Vella on behalf of the people, P87185.
All right. And so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court to remove the judge from this case. And regardless of whether that motion had been filed or not, or whether he intended for such a motion to be filed, I advised him that I was not comfortable with doing so and that I did not agree to do so for the purposes of this case. And as such, him and I discussed that this was going to be a stopping point in going forward with representation. And as such, we parted amicably. And at this time, I would ask to be allowed to recuse myself from this case, Judge.
So you're all right. So counsel, you are asking to be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you, and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. Peterson insisted that the only way that he would be comfortable with me representing him in this case is if I continued and persisted with this motion. I do not agree with the motion that he is filing, and he said that he would prefer to go on his own. if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship speaking wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
Okay. All right, the court will note that there was a motion that was filed today asking for this court.
For the videotape, hearing of bail and charges.
Okay, we don't have videotape. You can request a transcript, certainly. That's, yes, you can certainly request a transcript.
Yeah.
You don't need a motion for that. You can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it and not a transcript of the 7th, of January 7th, when we had a bail bond discussion and the charges of trespassing and assault in the city of Woodhaven. We did it over Zoom.
I understand we did it over Zoom, but we don't, that was not recorded over Zoom. It was
just a
recorded on our transcript.
Okay, well, I'm gonna have to file a motion for that, I guess, because I don't.
No, sir, what I'm saying is that you don't need a motion for transcripts. You can just request a transcript.
Okay, yeah.
There's a fee that you have to pay, but it's not a motion.
Okay, yeah, I request that. Also, I request on the Michigan Courtroom 2.003. I believe it's filed that on the 17th on Friday or something like that. So
okay, hold on, just a moment. Okay, well, counsel, I will allow you to, I will grant your motion to terminate representation specifically as far as moving forward, but counsel, I would just, if you can just stay on these proceedings.
Oh, of course, I would ensure, yeah, I have no problem.
Let me finish, please.
I'm sorry.
To advise Mr. Peterson appropriately if he's getting into some territory he shouldn't be getting into, okay?
Of course, Judge.
Thank you. All right, and so, okay, that's what this one is, that, okay, so this seems to be, so the motion you filed today, sir, is regarding the Zoom video that does not exist, but the transcripts you can certainly request, correct?
yes.
That's all of this one, okay. So let me make a note on here. So I'm just going to note, defendant's motion for Zoom transcript denied, as it doesn't, Zoom video denied, as it does not exist. Right, because you did that on, you recorded that, right, Ally?
On the 7th?
Yes.
I believe so, but I can't. I don't know. I have something from the 7th, but I can't click it while I'm recording.
Yeah, no, I think you came in to record on that day.
Mhm.
Okay, so I just wanted to confirm that, that was in fact done with, Ally, so we have the transcript only for that. Okay, and so then you filed something, let's see, I see something else on January 21st. Oh, this must be the copy of the same,
They'll give you 2 copies of each.
yes, yeah, okay, that's fine, okay, so there's that. You filed something on January 17th, and you're requesting our 2.003 to dismiss, disqualify the judge as follows. Filed the motion in good faith. Fair bond conditions and restrictions to stop U.S. public protests at City of Winnebago Public Schools. Are bias favors given to plaintiff? Okay, well, sir, I can tell you that that's not, that's a condition this court put in because that's what's alleged as a violation. So to protect the complaining witnesses, that's what the court put in. Just as in any assault case, sir, I put a no contact provision in. And so that is why I did that, not because there's any bias at all.
Well, if you keep
Not at all.
If you keep reading, Your Honor, you'll see that the U.S. federal court Judge Grant, Your Honor, because the city of Woodhaven tried to put a PPO on me, specifically told them, case dismissed, that he cannot
Okay.
violate my constitutional rights.
Okay, sir.
Now, and I
Yes,
believe that's the issue.
Oh, hold on, please, just one moment. I understand that you think that that's the issue. I'm not trying to violate your constitutional rights. What I'm trying to do is that there is, right now, that there's a complaining witness. There are allegations, and so the court, as condition of bond, has put certain parameters and conditions of bond on. Just as, like I just stated, just as if there is an assaultive, somebody with assault and battery or domestic violence, they're not allowed to return to the home or wherever the victim lives. They're not allowed to return to the victim's place of employment. They're not allowed to contact the victim. Those are all conditions I put in. Somebody with disorderly conduct, I put certain provisions in there, whether they can use alcohol or not use alcohol, whether they have to use testing or not testing. It's not intended to violate any rights under the U.S. Constitution. The purpose is for protection of the complaining witnesses and protection of society if this court deems necessary.
That's if somebody violated a law. I haven't violated nothing.
Sir?
I'm with you.
The allegation is that you assaulted, resisted, obstructed a police officer causing injury and trespassed.
That's
Now,
just an allegation.
you're correct. But as a condition of bond, there are certain factors the court has to take into consideration when assessing bond, and the court has judicial discretion to assess bond conditions. That is what this court did. I didn't place you on house arrest, told you you couldn't move anywhere. I didn't do any of that, sir. I simply put forth conditions relevant to the allegations therein. And sir, I'm very much aware that they're allegations only.
Yeah, you need to read the whole thing of it, just one. I got like 15 issues in there.
15 issues.
Yeah, you
Okay,
need to
so
read the whole thing. Also, Your Honor, I publicly protested today in front of your court,
okay.
but none of your police came out to arrest me because that's my constitutional right to do.
You're
I'm
correct.
not ignorant of my constitutional rights. I'm not ignorant. A judge told me a long time ago, ignorance of the law is no excuse.
Right.
And so I studied a little bit. I don't know a lot, but I know my constitutional rights. I've done read your European Constitution over and over again. Actually, I wrote one of my own. If I followed your white laws, I follow them, and then you stomp on me when I followed your laws. You've been doing this for hundreds of years. You know, Martin Luther King marched, and you guys
Stop
took
right
dogs
now,
out.
stop right now.
You
I'm
violated
not
our
100 years
rights.
old, so do not accuse me of stomping on anything.
Well,
Let's be very clear on that.
yeah, well, okay, yeah, it don't seem like it.
I'm not 100 years old, sir. Were you interfered with at all while you were engaging in your protest?
My constitutional right? No.
No, you were
I
not.
did at the city of Woodhaven though, and now you condemning me for it
No,
because
sir.
you restricted me.
Sir, let me be very clear.
I've committed no crime.
I am restricting, I put conditions on for the protection of the complaining witnesses, which is the authority that I've been given with my judicial discretion.
You also
Yeah.
took an oath to uphold every citizen's constitutional right to public protest, but
Okay.
you're not doing that.
Sir, let me clarify. Let me clarify something. There is a balancing act that as judges we have to do. So we have you're charged with a crime, right? It's an allegation. We have the protection of the victim and the community. All right? So there's a balancing act that this court has to do. And that is what this court is doing. I have not restricted all of your movement. I have not said you can't put signs up anywhere. You can't go on any public property. I have not done that, sir.
You did.
No. What I did was I addressed specifically the complaining witness and the victims in this matter. That is what I did, and that is what I have the authority to do that's been given to me by the U.S. Constitution as well. That's statutory authority. Whether you agree with that or not, sir. I understand you don't agree, but that's not a basis for this court to disqualify itself. Let's see what the next one is here. Okay, I don't know what bias favors are. not biased, prejudiced, discriminating against you in any way, sir.
That's your opinion.
And sir, let me just be very clear. The court has not infringed on your First Amendment right of free speech. What it did is it put in protections for the victim in this matter.
I'm the victim.
Which this court has every authority to do.
I'm the victim, and you're not recognizing that. I just protested in front of your courthouse and it was okay. You should have arrested me then. When I go to your schools and you're wind out, when I go to schools and you're wind out, you should arrest me, but you're not going to. It's
I
my
do
right.
not, let me just clarify. I, as a judge, do not have the authority to arrest you myself.
Well, they don't either. They took an oath to uphold my civil rights, whether they like it or not.
Sir, did anybody arrest you here?
You weren't supposed to. It's my constitutional right to do. Just like in the city of Woodhaven. This is what I'm trying to get through to you. You're trying to say, no, no, no. There's allegations against you that you did this, this, and this. I'm trying to tell you I exercised my constitutional rights and they violated me. I'm the victim.
And sir, that is everything that will come through discovery and whatnot. At this stage, this is considered pre-trial.
I know what this is.
So
I've been through your system before.
So
also, Your Honor, I've asked if you don't dismiss yourself, I'm asking for another judge to hold.
Just one moment, please. This court, sir, has to take the allegations and there's a process.
Like I don't know it. I know your process. I've been down your roads before. But
I don't know
on
what
15,
roads of mine you've been down, sir.
On 15,
But you've
the
been here,
defendant-
excuse me, you've been here in this court a number of times
Yes,
as
I have.
other matters have been disqualified.
Yes, I
And you
have.
have been treated with respect and fairness. And I believe you've even
that's
stated that
not
yourself.
all entirely true.
Hold on, sir. I believe you've even stated that yourself.
Yeah, but that's not all entirely true. You wasn't here to dismiss the posted signs, was you? You should have been here when the prosecutor dismissed City of Woodhaven posted signs.
What?
You didn't show up then.
Hold on, sir. I don't even know what one that is you're talking about.
Well, there was the one that we was going through and postpone. The City of
that
Woodhaven
the
wrote a
federal one?
violation. No, they wrote violations, for posted signs in this case, in other cases. Because I was protesting in the City of Woodhaven.
Okay.
But on the day that you were supposed to be here to have that case dismissed, another judge took your place. You think I'm sleepy or stupid, I'm not. But I'm 15.
Stop there right now, sir. Stop there right now. I don't think you're sleepy and I don't think you're stupid. When was that case? The one that you're talking about that I had another judge sitting for me, when was that case?
That was, I don't know the exact date of it, but I know the case was dismissed by a prosecutor.
Was that about a year ago, sir?
It was last year.
Last year.
Yeah.
Okay, well, the time that I had somebody sitting here in my place was because I had to go to Illinois on an emergency basis because my father had a stroke.
Oh, my fault.
So instead of having everything dismissed, I made sure I had another judge here to cover. So do not accuse me of thinking that you're sleepy or stupid. I made sure that there was a judge here to cover it anyway. So whether I was here or not is irrelevant.
The case got dismissed from the City of Woodhaven. But anyway,
That's
I'm 15, the defendant under Michigan Court Rule 2.003 requests a hearing by a district court chief judge in case if judge refuses to dismiss herself from this case. I know I have a constitutional right. If you don't dismiss yourself, I have the right for another judge to look at it. This way it's impartial. It's where another judge can look at it and not just yourself. And apparently you want to hold this case for a reason. And I believe that you in the City of Woodhaven, the state of Michigan is in conspiracy. You know what I mean? You guys can say I'm crazy or not, but that's what I'm seeing. Because if you're fighting so hard to keep this case in your court, there's something wrong. Something got to be wrong. You already violated my constitutional right to public protest at the City of Woodhaven because of allegations that I committed assault against the police officer. You guys don't even know me.
Sir, okay, stop right there, please, just one moment. So, I'm not fighting to hold on to this case. I was assigned this case by the State Court Administrative Office. Now, I'm also elected to preside over cases. So, unless there's a valid reason for this court to disqualify itself, I am obligated, whether I want to or not, to sit and preside over the matter. I am the chief judge of this court, and so I don't find that there's a basis at this point for me to disqualify myself. However, you certainly have the right to request the state court administrative office can review that. That is absolutely your right. That's how that gets reviewed.
Well, yeah, I want another judge to look at this, because if you don't want to dismiss yourself from this case, we got a problem right there. Because
There's not a problem, sir. I have a responsibility.
The city, whatever.
Sir, I have a responsibility. The matter is transferred over to the 27th District Court because the 33rd District Court disqualified itself. Perhaps they sent it here because the other matters that you've had here, I don't know. I didn't ask for the case to be sent here. It's random. I have zero, just as though when I disqualify myself from a case, it gets sent somewhere else. I have no control over where it gets sent. I have no control over what gets sent to me, whether it's from 25th District Court, 28th District Court, 24th District Court, 34th District Court, or the like, sir.
Well,
So, just so you're aware.
Well, I have a history of this 27th District Court in cahoots with the city of Woodhaven. I think the judge Ken Bash or something like that. He might be up there somewhere. He's retired now. You guys did me the same thing, same way you did.
You guys, I wasn't here.
Well, that's what I'm trying to say. Your system, you wasn't here, you're not 100 years old.
It's not my system. It's the system of the country. It's the entire system. You keep accusing this court that I'm 100 years old and I've been oppressing things for 100 years, that it's my system.
Well, I'm saying
I didn't arrest you. That is not
it's your system.
my system.
And regardless, this is your system. It's not mine.
It is yours. It's
No, it's not. I'm Native Indian African. I'm not even a citizen.
No.
No, I'm a prisoner in my own country because of you white people. Y'all need to go back home where you guys come from.
Okay, sir. Well, let me just say this. All right. You are accusing this court of being biased and prejudiced.
And racist.
Yep. And racist. However, your comment, sir, would seem to suggest otherwise.
Look, why do you raped us, you robbed us, and you murdered us legally?
Stop right there.
Everything that you people have done has been legal.
There. It's not you. I did not do that.
You're the system.
Do not put that on me. But here's what I'm going to do, sir. I'm going to grant your request. And this court's going to disqualify itself, and you can figure out which other court's going to handle this matter. After the state court administrative sends wherever it's got to send, whatever it has to send. Because at this point, I am not going to stay here, take the abuse from you and your allegations, which are completely false and unbased. This court, myself, did not do anything that you're accusing me of doing at all. I wasn't even around at that point. So we're going off the record. You can step outside in the lobby. Somebody will give you the next stuff you have to do.
And I'll give you a call, Mr. Kelly. Thank you very much for helping me.
That's all.
Yes.
There'll be another judge assigned.
So am I free to leave, or do I gotta get paperwork or something?
I believe that you're all set, sir.
Well, thank you. You have a good weekend and a good year. Thank you.
Good luck to you, sir.
'Cause I don't want to violate none of you guys' laws. That's forbidden.
Okay, I have to wait to write this file. All right, counsel, so there's that. So it won't be this court anymore.
Okay, Judge. I appreciate the judge granting my withdrawal. I will contact and make sure that counsel is appointed to Mr. Peterson if he wants it. But otherwise, thank you very much, Judge. Have a pleasant day, and I'm sorry it had to be this way.
Oh, you're all set. Thank you. Have a good day.
You too.
Are you able to hear me okay?
I can now.
Okay. Great. This is the date and time set for a sentencing hearing in this case. Mr. Kuhn, you're appearing without a lawyer today, is that correct?
Yes.
You understand that you do have the right to have an attorney?
You're on special appearance, so
You understand that you have the right to have an attorney?
I'm here on special appearance, sir.
I know, I'm asking you a question.
I'm here on special appearance.
Do you understand that you have the right to have an attorney?
I'm here on special appearance.
That's not my question. Are you going to answer my question?
I'm here on special appearance, sir. I understand I made a mistake, and I'm ready to try to solve this problem.
Are you going to answer my question?
I'm here on special appearance. That's all I can say.
So you're not going to answer my question?
I'm here on special appearance, sir.
Okay. I'm going to have you sit back over there for a minute. We're going to take up your case again. In a little bit, I need to decide how we're going to proceed if you're going to refuse to answer any questions here today. Okay? Nope, you're not handing anything to anybody. You're going to go sit right over there. Okay, officer. Okay. Are you able to hear me okay, Mr. Kuhn?
Yeah.
Okay, so I just want to explain a couple things to you. That I have an obligation to ask you certain questions to make sure that you understand what's happening with your case. And that's why I'm asking you whether you understand that you have the right to have an attorney and that you would have the right to have one appointed if you couldn't afford one. I'm just trying to make sure that you understand your rights, and it's my job to explain those rights to you. I'm not asking you to give up any rights. You're not putting yourself in any kind of legal danger by answering these questions. I'm just trying to find out if you understand what your rights are and how we're going to move forward, so that I know that you're knowingly and voluntarily choosing not to have an attorney to represent you. And if you don't answer these questions that I'm asking you, it impedes my ability to proceed with the hearing in the way that I'm required to under the law. You understand that?
How to answer that. All I know is I was told, when I've read and stuff, that I'm here on special appearance.
What do you think that means?
I'm not contracting. If there's no corpus electi, how could there be a crime?
Okay. Do you know what that even means?
There's no injured party.
What you're saying?
If there's no injured party, where is the crime?
Okay. Well, first of all, a jury found you guilty, right?
And that, I'm stepping
They
into
found you guilty of assaulting, resisting, or obstructing two police officers. Right? That's what happened.
I'm here on special appearance.
Okay. If you continue to refuse to answer my very simple questions just about whether you understand what's happening, and if you continue to just give me that answer, which doesn't make any sense and doesn't have any legal effect, no matter what you read or what other people have told you, then you're impeding my ability to proceed in the way that I need to under the law. And if you continue to do that, my only option is to impose a sanction on you until you do answer my questions. And what that means is that I'm going to find you in direct contempt for impeding the function of the court by refusing to answer very simple questions. And I'm going to put you in jail for 30 days. And if at any point during that jail stay, you decide that you will answer these very simple questions, then we'll come back into court immediately and we'll take care of the sentencing. But those are going to be your options, because I'm not gonna have you just.
Okay, well, thank you for clearing that up.
So it's your choice. You can answer my questions, or you
can
can
an attorney, but the attorney I had absolutely did nothing.
Okay, we're past that point. What we're here for today is a sentencing hearing, because you've been convicted, you've been found guilty by a jury of your peers. And so we're here for sentencing. So we're not here to talk about what did or didn't happen with your lawyer before. I'm trying to find out if you understand that you have the right to hire your own lawyer, or if you can't afford one, that one will be appointed for you. Do you understand that you have that right?
Yes.
And you understand that proceeding without a lawyer has certain risks. Do you understand that?
But I obviously can't afford an attorney.
Okay.
And the one I had, again, didn't do a dang thing because the ticket should have never been split.
Okay. Do you want to
That was my
request?
argument to begin with.
Do you want to request a different attorney to be appointed?
Actually, yes.
You did. Okay. All right. So you did previously qualify. So I find that you continue to qualify for a court appointed attorney. Court is going to appoint one for you, and we'll reset this hearing for my next available date. Okay.
Am I going back to jail or can I go home?
No, you're going back to jail until you have the hearing.
I've already had 3 weeks in jail, sir.
And you made that choice by refusing to comply with the pre-sentence process. That was your choice. You're just facing the consequences for your own choices. And if you have people advising you to take this ridiculous stand and make these statements that don't mean anything to the court, they're giving you really bad advice. And they're not the ones paying for that advice, you are. And I think you need to start listening to a lawyer who actually knows something about the law and not what you read on the internet or what people tell you because they don't know. And you're taking their advice and you're paying the consequence for their bad advice. They're out doing what they want to do. You're the one who's in here in jail. So I would suggest that you start listening to a real lawyer and not what you read on the internet or what people are telling you who really don't know what they're talking about. So that's the way we're going to proceed. We'll appoint an attorney to represent you at the next hearing, and your bond is going to continue to be revoked until that time. What's that?
And when will that be?
As soon as I can get it on the schedule, probably about 2 weeks. So, any?
No, I'll let Mr. Thompson know that he was a side counsel so we can get somebody in there quickly.
All right, that's all for this hearing today. Our next hearing is set for 11, so we'll be in recess until that.
The next case is LaTanya Denise Turner versus Brian K. Widener, State of Georgia, Salah Holdings, Define Gresham, and Larry W. Johnson. All right, is there Ms. Turner, LaTanya Denise Turner?
Yes, I'm the attorney, in fact, on behalf of the principal, who is the resident agent. I have also already submitted forms appointing the judge over this matter to administrate on behalf of the principal. And I also submitted the rest of my entries on records. Now, with that being said, the Form 56 appointing judge.
Ms. Turner, I gotta see you first.
Okay. I'm trying to, there I go.
Okay, there you are. All right,
Okay.
so Ms. Turner, very quickly. I've reviewed the information that you provided. First of all, you're suing with respect to a foreclosure, which is a situation that involves land and a determination of ownership with respect to land. That is not my jurisdiction. I'm in state court. State court does not have jurisdiction over determinations of land. We deal with dispossessories, which is a temporary situation with respect to land, the allowing someone to use your land in exchange for rent or your property in exchange for rent. But we do not deal with the whether a foreclosure is proper. So in this case, this court is going to have to transfer your case to the Superior Court of Clayton County, depending on whether this is Clayton County that's involved. And so I see you're suing the state of Georgia. Not sure how they're involved. Not sure how any of these parties are really have an interest in this case. But with respect to the jurisdiction with for foreclosures, that is not what I do. Okay. All right, is there anyone else here on behalf of any of the other parties who either disagree with what I've said or who have anything that they would like to put on the record?
So, Your Honor, this is Larry Johnson. I
Yes.
represent Brian Widener as well as myself. I just
Okay.
want to point out to the court, this was initially filed and I was not named. And
Okay.
after I filed an answer on behalf of Mr. Widener, the plaintiff just stuck my name and added it to it without a court order. And at that
Okay.
point in time, she needed a court order. So I'm not personally, I mean, I'm only in this case because I filed an answer for
Yeah,
Mr. Widener.
intended to name me too. So, Ms. Turner, I know you have a set of beliefs about how the law works, but the way we do it here is just because somebody files on behalf of another person, everybody's entitled to have an attorney represent them. And so you can't then sue the attorney for giving them a defense. So everybody who comes into the case doesn't get sued individually. Like there are people who are responsible allegedly for what you are contending happened, but then there are other people who they choose to hire to help them navigate the case. For the people who are navigating the case and for the judges who are dealing with the case, you don't get to sue them because they don't have an interest in at that level. They're just trying to help the other person navigate the case, okay?
Could I get finished recording my interest on record?
No, ma'am. You've done that. You're the plaintiff.
Okay. Well, Judge, I would like to record my interest on record.
I'm not sure what that means, ma'am.
I'm the attorney of fact on behalf of the principal, who is the registered agent. I already submitted the Form 56 upon you over the matter to administration on behalf of our principal.
Ms. Turner, nobody gets to appoint me over the case. I'm already appointed to whatever's assigned to me through the clerk's office.
I appointed you through my for my trustee, and Your Honor, I would like to add also to the case and ask you a question.
No, ma'am.
Yes or no?
The question that I'm not going to answer any questions because this is not my jurisdiction. I'm going to transfer the case to Superior Court and let them sort it out because land use and land and interest in land is under the jurisdiction of the Superior Court. Okay, so we'll get you an order. We'll also dismiss Mr. Larry Johnson from the case pending whatever the Superior Court decides because he's only here to represent the defendant, which the defendant has a right to hire an attorney to represent them, and that attorney doesn't deserve to be sued because they are helping somebody defend themselves.
This case is also in the federal court also.
Okay, then if it's in federal court, then it probably doesn't need to be here also. You shouldn't have a case running in two different courts at the same time. Okay, that's just going to cause confusion. And you're not going to achieve what it is you wish to achieve.
Okay, Your Honor, I know this court has no jurisdiction per 12 CFR 1500. And also, is there or should there be an investment in private residential property in the United States? Or is deposit?
That is a question bigger than any of us can handle. People can invest in whatever they spend their money on. So at this point, I think that you're going a little bit too far afield. Like I said, we're going to go ahead and transfer this case to Superior Court, and my brother or sister judges on Superior Court will help you sort out what it is going on. Okay. All righty. So we'll go ahead and get an answer out to all of you. Get an order out to all of you transferring this case to Superior Court. But just as an aside, Miss Turner, everybody who comes in as a representative of somebody else, if they're an attorney, don't sue them because it just makes the case harder to get through. Okay, if you want to achieve something with respect to finding out what happened with your foreclosure, don't keep adding people to the
Your Honor, in this executive branch of law, I have a right to sue the attorney, anyone else involved.
Ms. Turner,
in this executive branch, I do have a right to sue them and anyone else involved.
Is nonsense. None of what you're saying makes sense. None of what, Ms. Turner,
it's federal law.
Ms. Turner, We're not in federal court. None of what you're saying makes sense. You haven't established an estate. There's no trustee. You're giving us word salad. You're just saying stuff that you've read or somebody told you was appropriate. It's essentially called a sovereign citizen, but
no, it's not a sovereign. It's not. I'm not a sovereign citizen.
If those things
No,
work,
don't put
everybody would
don't put that on me. I'm not a sovereign citizen.
Turner, you've made statements that sovereigns use, and so
I have my trust set up, and I'm not a sovereign citizen.
Yes, ma'am.
I am a person working in my trust.
Okay,
not a sovereign citizen.
All right,
that's against the law.
Okay,
I'm not a sovereign citizen. So I have my trust set up.
Okay.
In a way that it's working for me, and I have it set up.
Okay.
And that's what I'm working on, my trust.
I'm not threatening you. Say one more word and that's 30 days. 30 days.